And we will then move to item number 8, SB 600, Senator Pan.
Thank you. Good morning, Mr. Chair, members. I rise to present SB 600, a measure that will amend the Jesse Unruh Civil Rights Act of 1959 to outlaw discrimination on the basis of citizenship, immigration status, and language. California is the heart and soul of a nation built by immigrants. California is also the home to the most immigrants out of any state. We are a true testament to the strength, innovation, values, and leadership our immigrants provide. California also leads the country in the diversity of immigrant status and linguistic diversity. Unfortunately, our California immigrants are some of the most vulnerable to discrimination, hate crimes, and unequal access to the most basic daily functions. Among verified cases of discrimination are instances where persons were denied service or asked to leave establishments because they were conversing with companions or their family in a foreign language. Other examples include day laborers barred from establishments near where they congregate, persons denied entrance to entertainment venues, or denied service when they present proof of age with a foreign passport or foreign government-issued identification card, and radio and other business contests that restrict participants and winners to, quote, legal, unquote, residence. While these individual occurrences may seem trivial to some, they all reinforce an awful atmosphere of discrimination and unequal access to services which should not be tolerated for any Californian. There are not many filed court cases challenging discrimination on the basis of citizenship, immigration status, and language because these forms of discrimination are not illegal, and because these discriminatory acts target those less likely to understand their rights or less likely to assert their rights out of fear of unforeseen consequences for themselves or their family members. The U.S. Supreme Court has held that, quote, citizenship and language are not the same as national origin, and that federal constitutional civil rights protections are not covered by the national origin characteristic. Therefore, there is a need to protect these individuals from discrimination in the Unruh Civil Rights Act. As a matter of principle, California should provide clear notice that we will not tolerate discrimination in public accommodations. SB 600 addresses the ongoing discrimination against our immigrants in California, and in doing so, our immigrants who are key to California's success and strength, but who are also among our most vulnerable to discrimination, will share the same civil rights protections as all Californians. SB 600 does not have any formal opposition and is supported by a wide coalition. I respectfully ask for an aye vote. And I have witnesses here to testify in support: Jorge Castillo, an attorney at Maldef, and Jeanette Zanapanan, who's also from Maldef, who's here to also answer any technical questions. Thank you.
Your first witness, please.
Good morning. My name is Jorge Castillo, and I'm a staff attorney with the Mexican American Legal Defense and Education Fund. For over 45 years, MALDEF has worked to promote Latino civil rights in the United States. And helping our efforts here in California is the Unruh Civil Rights Act, which has no doubt protected thousands of immigrants, Latinos among others, since it first became law in 1959. Even so, from time to time, it has made sense to amend the law to make explicit that certain forms of discrimination are intolerable in this state. We are co-sponsoring Senator Pan's SB 600 for two main reasons, although there are many reasons to favor this bill. First, we think the current state of the law provides us an opportunity to clarify for all California businesses and business owners that they may not discriminate on the basis of citizenship, immigration status, and language. That issue warrants clarification because the Supreme Court of the United States, in interpreting federal law, has previously held that citizenship and language are not the same as national origin. Now, California law is different from federal law, but there is no reason to leave unanswered the question of whether these are protected characteristics or whether they are outside the limits of the Unruh Civil Rights Act as it has been interpreted by the California Supreme Court. In other words, any confusion about whether it is illegal in California to discriminate on the basis of citizenship, immigration status, or language is just bad business and bad for business. The second major reason that we're sponsoring this bill is that the people it will explicitly protect. Even today at MALDEF, we regularly hear about discrimination in California on these grounds, and Senator Pan described some of them, including day laborers who have been barred from patronizing establishments where they congregate, like a hardware store. People denied entrance or service because they present something like a foreign passport to prove their age or to prove whom they are. People denied services unless they speak English to the clerk. And these are issues that might seem trivial or not major, but the reality is they happen every day, and together they reinforce an atmosphere that denies full inclusion for these people. Not only that, oftentimes this is the community that least understands their rights, and even if they understand their rights, are least inclined to try to enforce their rights unless it's clear on their face because of fear of exposing either themselves or their family members. So for these reasons, both for more clarity for California businesses and more protection for these vulnerable Californians, we strongly urge an aye vote.
Thank you. Next witness.
So Jeanette Sanipatin, also on behalf of MALDEF, but I'm also here to speak on behalf of the California Civil Rights Coalition, who is also a co-sponsor of the measure, also in strong support.
Thank you.
I'm just here to answer questions. Thanks.
Thank you. Anyone else in support?
California Immigrant Policy Center in strong support.
Thank you. Anyone else in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Mr. Chu?
Move the bill.
Thank you. We do have a motion and a second. Mr. Gallagher? Or Mr. Wagner?
Yeah. Okay. All right. I was inclined to support the bill, but I'm reconsidering that, and I'll tell you why. First of all, I think the premise of your bill is entirely wrong. And the reason I think it's wrong is very well summarized by the attorney from MALDEF, and I wrote down what he said. It's bad business and bad for business, this sort of discrimination. I am unaware of any business anywhere, especially in this tough environment, who would ask someone to leave because of citizenship. I mean, first of all, it's very rare that you're going to know the citizenship of the person that you're dealing with. Maybe a couple of cases where passports have to be used for whatever reasons, but nobody walks around with a sign on them that says I'm here legally or I'm not here legally or I'm a citizen or I'm not a citizen. So the only issue where you would know would be the language that somebody is speaking. And I was inclined to vote for the bill because I think it does absolutely nothing. And so what's the harm? I am, however, now concerned that there will be some harm, because there are other reasons why a hardware store might not want people, no matter where they're from, whether they're here with documentation and citizens, they're not here with documentation, whatever, might not want them congregating on their front lawn or in their front door. There might be a reason why if you can't communicate with the clerk can't help you. And the reasons aren't discriminatory. The reasons are nevertheless, under this bill, going to lead to lawsuits. And we just don't need more lawsuits for something that, as I say, I don't think you've shown happens with any degree of regularity. Why not? Because, as we know, quote, it's bad business and bad for business. You're not fixing a problem that exists out in the real world, and you're going to cause more problems, as we seem to do with some regularity for our business owners. Come back with evidence that it's happening, and maybe we relook at it. But I just worry that you're opening up a can of worms for, as your own witness says, no good reason.
Is anyone else? Mr. Alejo?
Just wanted to, I was going to speak on this bill, but just to respond to my colleague's comments, one, it's factually incorrect that they will never know the citizenship of someone other than their language, because just as a very practical example to prove that you're wrong is that when an employer hires someone and they fill out the I-9 form, there's a column A for documents to prove their identity, and then column B to prove their entitlement to be employed. And one of those documents is a lawful permanent residency card or other documents. There's a series of documents that they could show. So that's just in a real life situation. That's how an employer would find out their citizenship.
May I?
Right. So what you're saying, what you said earlier, is just factually not true.
If I may, to my friend from Salinas, that's in the employment context, and I can understand that. And there should be no discrimination in the employment context. This is beyond. My concern is this is beyond employment. This is in giving and receiving services. So, with all due respect, sir, I don't think that example makes the case, and I appreciate you allowing me to respond.
Thank you. Mr. Gallagher?
Yeah, just a question, but real quick. I mean, I think what we're talking about in this instance is customers of a business. So a customer who comes into a business, you're not necessarily going to know, I don't know, on any circumstance, unless there's a passport involved or something, where you're going to know what that person's citizenship is. In the employment context, I think I agree with you. But this is talking about just customers coming into a business that's open to the public. Now, my question, though, is why wouldn't this be covered by national origin, which is explicitly in the statute? And also, because the case law surrounding the UNRRA Act says that it applies to all discriminatory practices based on the classifications listed in the Act or similar personal traits, beliefs, or characteristics that bear no relationship to the responsibilities of consumers of public accommodations. So if somebody really was discriminating, based on someone's language, well, that's linked to their national, that's linked to that same trait that's listed in the statute. Or their citizenship would also be a trait that's linked to national origin, whether they have citizenship or not. So all those things, I think, would already be covered by the national origin characteristic, or if not that, by the expansion that if you're seriously refusing service, not as a matter of function, because as I think Assemblymember Wagner pointed out, there could be a reason why you don't want a bunch of people congregating out front that has nothing to do with their language or national origin, etc., but just based on the function of the business. And also, when you're dealing with someone, if there is a language barrier and you can't serve the person because you don't understand each other, that's more of a functionary thing rather than a innately discriminatory just because you don't speak the same language. And that's what we don't want to do, is sort of open up the door to frivolous lawsuits that might be brought based on that. And instead, just the law already seems to cover this issue, that if you are truly refusing service to someone solely based on their language or their immigration status, citizenship, that's already going to be covered under the statute, right?
Well, actually, unfortunately, no. There have actually been two court cases at the U.S. Supreme Court, which basically indicates that national origin, while we would hope would cover these things, actually do not. And but since I'm not the attorney, I'll perhaps let the attorneys answer that question. And also, if it's okay, Mr. Chair, to also maybe cite a couple of more specific examples in addition to what I already presented regarding examples where this kind of discrimination is taking place.
So thank you for the opportunity to answer your questions. I think to give some very concrete, real-life, everyday scenarios in which national origin and citizenship come into play. Think about every time you present a credit card. My credit card says CID on the back, and even though a lot of times they don't ask that, if your only ID is your passport, is your matricula consular card, that is the ID you're going to be showing. Every time you write a check, if you don't have good credit, oftentimes they look for a form of ID to prove who you are. These are everyday scenarios that real-life people in California face, where they're exposing their citizenship, where they're exposing their place of origin, essentially, but not just their place of origin, but where they are currently citizens of. Also, the language issue is something that comes up pretty regularly. I'm sure you all have met people in your lives who strongly believe that this is, in America, we speak American, but the reality is in California, we speak over 200 languages. And so these are realities that are faced every day, and clerks see this every day. And people have been denied services on these bases in this state. About the whether it's covered in national origin or not, these issues, the reality is California courts have no published decision, which are what's binding here, going one way or the other. The only authority we have are the federal courts interpreting federal law. And they have said these are not covered in national origin. One of the reasons why we may not have a published decision on these lines is the reason I was mentioning before, that these type of people are more vulnerable to these kinds of attacks, but least savvy about their rights and most apprehensive about the legal system. So some sort of clarity for businesses to show them that they can't do this kind of proactively is something that would protect these vulnerable citizens of California.
Thank you. Other questions, comments? Senator, you may close.
Thank you. I appreciate the discussion. Again, this is a real problem that's happening right now. I'll tell you, as a child of immigrants, my parents, their primary language, although they knew English, was not English. I saw examples when I was growing up. I think that it's time for us to move this forward. I also would point out that there's no formal opposition. There are many groups, of course, who are concerned about things like frivolous lawsuits, and they have not expressed the concern that this bill will generate that. And so I respectfully ask for an aye vote. Thank you.
Thank you. We do have a motion and a second. It is due pass. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Aye. Alejo, aye. Chow? Chow, aye. Chu?
Aye.
Chu, aye. Gallagher? Garcia? Holden? Holden, aye. Mainshine? O'Donnell? Aye. O'Donnell, aye.
That bill is out. Thank you.
Thank you.
That brings us now to item number 1, Senate Bill 188. Senator Hancock. Good morning.
Good morning. And Mr. Chair and members, SB 188 eliminates the sunset date in existing law and would allow the East Bay Municipal Utility District, known as EBMUD, to continue to collect delinquent charges for water and wastewater through liens on the property tax roll, as opposed to really having no choice except to turn off the water for tenants in master metered buildings, even though those tenants are paying for water through their rent. It's modeled on the authority that many other water districts, cities, counties, municipal utility districts already have, and has worked very well for the 5 years in which it's been in effect. EBMUD has stopped terminating service to master metered multifamily residential buildings. They've kept the water on for over 1,000 tenants. And the bill clearly states that when water is separately metered and a tenant responsibility, the landlord is not affected in any way. So with me today are Marlene Dumaine from EBMUD and Steve Wallach with Alameda County.
Thank you. First witness, please.
Good morning. I'm Marlene Dumaine with the East Bay Municipal Utility District, and we are co-sponsors of this measure. I'll keep it short. This authority has been very, very important for us. Our collection rate has increased from around 15% to over 90% since we've implemented this program. We think it's a good program, and we'd like to see it continue.
Thank you. Next witness.
Steve Wallach on behalf of the Alameda County Board of Supervisors. We're also a co-sponsor of this bill. This is a program that's worked. It prevents from unduly penalizing the tenants or even the other ratepayers. And so we urge your support in allowing this program to continue.
Thank you. Any other witnesses in support? Seeing none, any opposition? Seeing none, we do have a motion and a second. Any questions, comments from the committee? Seeing none, Senator, you may close.
I would respectfully ask for your aye vote.
Thank you. The motion is due pass to appropriations. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, no. Garcia? Holden? Holden, aye. Mainshine? O'Donnell? O'Donnell, aye.
That bill is out.
Thank you so much.
Thank you. That now brings us to item number 4, SB 272. Senator Hertzberg.
Good morning, Mr. Chairman and members. Still is morning, isn't it?
Yes, it is. 10:30.
Good. In 1968, the California legislature passed the California Public Records Act to mirror the then recently passed Freedom of Information Act by the federal government. From 68 up until 2004, there was a lot of game playing going on. If you read the cases and you read the relationships and the tensions as citizens and newspapers and the like tried to gather information from their government. How do you pay for it? What do you do? How do you define it? And it was problematic. So the people of the state of California in 2004 passed Proposition 59 by nearly 10 million votes, an 83.4% margin. And they voted to include the Public Records Act in a much broader context in the Constitution of the state of California. And they dramatically broadened it, and I want to reference 2 sections of the Constitution with respect to the fundamental change to do that, because the analysis references case authority that occurred prior to the constitutional change by more than a decade. It says, Section 1, the people have the right of access to information concerning the conduct of the people's business. Not a document, but the right of access. It goes on in Section 3 to be clear as to what the depth and dimension of that right of access meant. Wasn't just a document, but it says, Section 3, in pertinent part, that this provision shall be broadly construed if it furthers the people's right of access, and narrowly construed if it limits the right of access. That's what the Constitution says. The Constitution is a document that supersedes and is more important than statutes. In 2014, the people again spoke with Proposition 42 to further this constitutional right of access to local governments. Indeed, there were challenges, and indeed there is a historical tension since Prop 13 of local governments about this idea of unfunded mandates, but it was settled by a vote of the people, despite what people want to bellyache about. So, as the chairman appropriately asked me when we met, what are you trying to do with this bill? What's the purpose of this measure? Appropriate question. What we are trying to accomplish is this, is that we're trying to ensure that the constitutional right of access applies to local government. And I'm asking that they provide the fundamental tools to give meaning to the word right of access, so that you actually are able to respond to the constitutional mandate. Basic informations about the systems of government and the information technology system so the public can, in fact, get access, as I say. The best example, he's not here now, is Assemblymember Mainshine. Before he was a legislator, he put together Project 25 in the city of San Diego, which was really all about data sharing between social services, police, hospitals, shelters with respect to homeless people, and was able to dramatically reduce the cost of government and increase the kinds of services that were provided to homeless people. The city of San Francisco has done the same thing with real-time data transfer, saving more than $1 million and reducing the number of 311 calls by 27.1%. The Public Policy Institute, on where I used to serve as the executive chairman of that board, is always trying to fight government to try to make a determination as to whether they can get information. They're trying to get information from the Employment Development Department to look at business transactions to enhance business. They're looking to health care and foster care and realignment, a big issue, and trying to get to the very data sharing that Assemblymember Mainshine was doing in the city of San Diego. And so we're asking for nothing more than a roadmap, a dictionary, if you will, or a menu for a restaurant. I would say to you, for example, by way of example, what does this mean to the members? What does this mean? Now, maybe some members of this committee
Permission to use a prop is granted.
What? Thank you very much.
Permission to use a
I
prop
have 3
is
props,
granted.
if that's okay, Mr. Chairman.
Granted.
Thank you. Well, not everybody can understand what that means. And what if I told you that every 5 years we're going to amend what these characters are going to mean? If you tell me I have a right access to government and I get a piece of paper that says this, it, by the way, says the Asm Judiciary Committee, or a document that says this, would I really understand what government is doing? This says Chairman Stone, by the way, or in Greek, or what this says. This says Vice Chairman Donald P. Wagner in Farsi. You can have it. I'll give it to the sergeant. In Farsi. My point is that in the computer language, we change the language. We need to be able to provide an access to folks to give meaning, as the Constitution asks, to what this is about. This is what we're doing in this bill is an initial building block, as will be discussed by the witnesses, in the first effort to try to really understand open data. We have seen in the private sector open data do incredible things. I have this device in my pocket that counts my steps, or can tell me my heartbeat, or can order a car, or, this is much better than we had with Dick Tracy when I was a kid, or anybody else. And who knows what the future is going to bring. The question is, we in government all the time try to solve problems. And what we need to do is to open it to the imagination and creativity of folks that are way beyond the people that are there every day. What happens in government, in my experience, so often is that the developers, the vendors come to us with solutions for their product. And they make the arguments, and they hire the best advocates, and they want to come and tell us what kind of system they want to sell us. And they've sold us thousands of systems in local government. The challenge for us as we start moving into the big data realm is to not just respond to the vendors, but to really ask the tough questions and to figure out how we're going to develop a system. If I'll be here, hopefully, for the next 4 years, and if I get reelected for 8 years, and I intend, as I expressed to the chairman, the notion that I want to really, together with Assemblymember Mainshine and others who are working on this, Ed Shao and others who are working in this technology field, to give a bigger think about this. And so when I consulted the best experts, it really was this catalog, this inventory of where we go to start to say, are there commonalities? Are there things that people can do with government, with a payroll system or whatever else it may be, to make it work better? I don't know the answer, but I know if we're going to be a great government that we talk about in California, we have to start on the mission. And you know what? If we make a mistake, we get up and we do it again, and we do it again, and we do it again, because that is the innovation and creativity of what we're about. And so there's been a lot of folks, certainly the number of the communities, you'll see the depth and breadth of support of this bill, and there's been a lot of the people who operate the government on a day-to-day basis who will tell you all the reasons why this thing is horrible and why it's going to affect them. Well, you know what? If we're going to be good in government, we got to be better than that. We've taken 7 amendments that weren't reflected in the analysis. There's another 4 which I expressed to the chairman and to Mr. Mainshine that we'll take in his committee if we get that far with respect to solving some of the minutia that's been talked about with respect to this measure. But it really is a much deeper dive of what we need to do. Is there residue for folks that are angry because we've passed 42? My answer to them is get a life. The law has changed. The people of California have spoken. This is going to be different today. And are they going to bellyache about it? We're going to figure it out. I don't know. Be responsive, be respectful, but be forward-thinking in terms of what we do. And so I have with me today as witnesses Leah Deasing, who's the Chief Technology Officer of the City of Riverside. She's here in her expert capacity. She's written articles all over the country to talk about this. She was one of the folks that we consulted with respect to trying to figure this out. And Rob Conkey of Grassroots Labs will testify as together with others who will testify in support. I thank you, Mr. Chairman.
Thank you. Your first witness, please.